What is appellate review? Appellate review is the scrutiny a higher court applies to the decision of a lower court to determine whether the judgment was correct in law, whether the facts were reasonably assessed, and whether the proceedings respected procedural guarantees. Put simply, a superior court rereads the case record and decides whether to affirm, correct, vacate, or send the matter back for further action. A bit of history. In common law systems, appellate oversight grew out of ancient writs, such as the writ of error and certiorari, devices by which superior courts called up the record to check for legal mistakes. In continental systems, the idea of a double instance took shape with appeal as the ordinary remedy, and above that, extraordinary review, like cassation, aimed at unifying the interpretation of law. Over time, most legal orders have acknowledged, especially in criminal matters, the right to have a conviction reviewed by a higher court as a safeguard of justice. How does an appellate court work? First, review is largely record based. It relies on the evidence already taken, the trial transcripts, the rulings, and the parties' briefs. A full new trial is exceptional. Second, the appellant must identify the alleged errors, legal, factual, or procedural, often called assignments of error or grounds of appeal. Third, everything is filtered through a standard of review, which fixes how much deference the appellate court owes to the lower court's decision. The most familiar standards are three: de novo review for pure questions of law. The appellate court owes no deference and interprets the law afresh. Clearly erroneous or manifest error for findings of fact. Here, the appellate court respects the trial court's vantage point and will not disturb factual determinations unless the mistake is obvious. Abuse of discretion for rulings that involve judgment calls, admitting evidence, managing discovery, imposing procedural sanctions, where the appellate court intervenes only if the choice was unreasonable or outside lawful bounds. Alongside these, the harmless error doctrine says not every mistake warrants reversal. If the outcome would have been the same without the error, the judgment stands. In the other direction, plain error permits, on rare occasions, correction of the grave, unpreserved mistakes that threaten the fairness or integrity of the proceedings. Possible outcomes vary. The appellate court may affirm the decision when no prejudicial error appears. It may reverse and render a new decision if the record permits final resolution. It may vacate and remand, sending the case back to the trial court with instructions, perhaps to apply the correct legal test, to take additional findings, or to hold a narrowly tailored hearing. Sometimes it may dismiss the appeal for lack of jurisdiction or because the order is not appealable. Appeals are governed by technical requirements. They must be filed on time and by a party with standing. Objections typically must be preserved below to be reviewable above. Appellants bear the burden of crafting a coherent argument supported by authority and citations to the record. Without a clear record, transcripts, exhibits, and orders, it is difficult to upset what was decided. Let us ground this with examples. In a civil dispute over the meaning of a contract clause, the appellate court will often review the legal interpretation de novo, while leaving witness credibility findings undisturbed absent clear error. In a criminal case, where the trial court admitted evidence obtained in violation of rights, the issue is largely one of law. If the tainted proof was decisive, the conviction may be vacated and the case remanded for a new trial. If a judge imposed an unduly restrictive preliminary injunction without adequate reasoning, the appellate court might find an abuse of discretion and narrow or dissolve the order. A few curiosities. Many appeals are decided on the briefs. Oral argument exists, but is typically concise and strategic. Collegial courts sometimes rehear cases en banc, that is, with all active judges, to resolve conflicts or address issues of exceptional importance. And amici curiae, friends of the court, can supply technical context, comparative perspectives, or policy insights that assist the court in shaping a sound rule. Above, you have more videos to keep learning law. Remember to give us a like and subscribe.